Good afternoon, ladies and gentlemen. We'll start day 3 of this jurisdictional hearing. Before we give the floor to the respondent for its closing oral submissions, are there any housekeeping matters we need to address at this stage? On the respondent side?
Simply the tribunal indicated in its agenda that the parties would have the option to save some of their time for response after the other party's presentation, and we would like to reserve whatever time is left after our presentations for response.
Now, this would be strictly a response. It wouldn't be introducing new points.
No, it would be strictly a response to what they said, if it's necessary.
I'm sure that's something that both sides had in mind when they made the points respectively yesterday evening. Is that correct?
That's correct.
Well, let's work on that basis. Is there anything that the claimants want to raise at this stage?
Yes, Mr. Chairman. First of all, I'd like to introduce Mrs. Catherine McLeod-Seltzer, the chairman of Pacific Rim Mining Corp., who has been able to join us today. And secondly, I'd like to raise the issue of the new document that we gave to Respondents' Council yesterday afternoon. Just remind the Tribunal that is an excerpt from the Foreign Affairs Manual of the United States government entitled Assistance to Citizens Involved in Commercial, Investment, and Other Business-Related Disputes Abroad. We believe that this document must be admitted for several reasons. First of all, it is a document of public record. Secondly, it isn't a very long document. It's only 8 pages long. And it is, I think, a document that has become very relevant in light of how, I wouldn't say important, but how relevant the U.S. government's involvement in these proceedings has become. It wasn't as evident previously. I think it has become more evident as the last 3 days have progressed. And I think if you balance the respective interest here, that is, whatever prejudice the respondent might suffer, if any, by virtue of the admission of this public document against the jurisprudential, I would say jurisprudential and public policy interests of your deciding an issue of first instance, i.e. the dispute over how to interpret the scope and effect of the CAFTA denial of benefits provision without taking into consideration this document, prudence would counsel in favor of admitting it, and then for the Tribunal to determine whether it is or not relevant to its determinations as it deliberates. And that's leaving aside the prejudice that we would suffer by virtue of the document not being admitted. Thank you.
Do the respondents want to respond to that at this stage?
Yes, we would.
Please do.
To begin with, I don't think claimant can claim any prejudice if the document is not admitted. As claimant's counsel has indicated, this is a public document that was fully available to them at the time they prepared their written submissions. They've indicated no reason whatsoever why they failed to file it in a timely manner. While it is only an 8-page excerpt of the document, the full document of the Foreign Affairs Manual is in fact many, many hundreds of pages long, and therefore to understand the context of this submission, one obviously has to have access to the full Foreign Affairs Manual, and there is in fact no heightened relevance of the United States that's come to light since El Salvador's last written pleading. The denial of benefits objection was filed before they filed any of their written pleadings. Every issue that this document addresses was fully in the record in the written pleadings, and there's just no reason to allow them to file this document out of time. Not to mention the procedural issue that while we all had overnight to prepare for today, the filing of a document like this, we had to deal with it last night, and it is, unless there is a good reason to do it, I don't think it should be permitted as a matter of course.
Mr. Chairman, if I may have a brief right of response.
Brief reply.
First of all, I would simply remind the Tribunal and my friend Mr. Smith that we received a number of documents yesterday in the midst of cross-examination, which should have been produced to us before. And secondly, we will have another round of written submissions, and certainly within the context of that round of written submissions, where we aren't submitting our written submissions until, I think it's June 10th, there's more than adequate opportunity for Respondent to review this document and the entire Foreign Affairs Manual, if it so chooses, for purposes of that submission. So I don't think they'll suffer any prejudice.
Let's stop the debate there. Do you need a decision before we give the floor to the respondents? Because we need to deliberate about this application, and we'd rather get on with the respondents' closing oral submissions and then take our deliberations during the break.
We do not need a decision, but I do want to point out that the documents that they were provided...
You made that point, don't worry.
Okay.
We don't have to retread every issue. So we'll come back to this during the break. We need to deliberate between the three of us. And rather than hold things up now, we'd rather give the floor to the respondent. But for the moment, don't refer to this document, even though you may have prepared for it.
Slides, yes. No, no time for copies, however. I apologize for that.
We have them later because they tend to be quite useful.
Yes, of course, they're being prepared. Thank you, Mr. President, members of the Tribunal. Again, I'm Derek Smith of Dewey and LaBeouf, appearing on behalf of El Salvador. I am going to give our final observations based on the arguments and testimony that was adduced over the last 2 days. I will address our objections of abusive process, ratione temporis, and the lack of jurisdiction under the investment law. After I finish, Mr. Badini will address our objections based on denial of benefits. And I'd like to thank you for the questions that you presented yesterday, as they have allowed us to focus our comments on issues that you consider important. And I will organize my presentation based on your questions, although not exactly in the order in which you have asked them. And we will reserve answers for some questions for the written submissions rather than address them now orally. And finally, we reserve the right to supplement any of our answers in the written submissions. And I will, of course, make some additional comments that are not directly in response to your questions. Your first set of questions relates to our abusive process objection. I would like to make some general comments before addressing your specific questions. You will recall that there is a two-pronged test for abusive process, and that El Salvador has demonstrated that both prongs have been met in this case. And I'd like to comment briefly why this simple test established in Phoenix Action and Mobile should be maintained, and that claimant's assertion that a new heightened burden to prove subjective bad faith should be rejected. First, bad faith is inherent in this type of abuse, as we discussed during our presentations. Second, claimant's new standard would invite a complex and impossible inquiry into the subjective motivations of individuals, but also of legal persons. Abusive process could never be established if it was required to show subjective bad faith. And finally, the current test is clear and simple to apply. All investors, states, and future tribunals know exactly what is prohibited. Investors know what conduct to avoid, states know what their rights are, and judicial consistency will be a relatively simple matter. All of this would be lost if you adopt claimant's approach. Now let's go back to the facts of this case. As we indicated, the first prong of the test has been met. Claimant has conceded that the change of nationality was necessary for claimant to access access jurisdiction. In fact, claimant has conceded that access to jurisdiction was the primary reason for the manipulation of Pacific Rim Cayman's corporate structure to change its nationality. This is from Mr. Schrake's testimony yesterday, day 2 at 4:54:12 to 22. Question: is it your position, your truthful position, that the primary reason for changing the nationality of Pacific Rim Cayman was to save these few $1,000s in fees? No. There were numerous reasons. You said primary reason, right. There were numerous reasons to move it to Nevada. So saving money was not the primary reason, it was one of the reasons.
Just reading that, is it fair to say that he conceded that it was a primary reason? I don't read his answer right as meaning that you were right. I just heard your question.
I read it, I understood his answer as indicating. He said no. I said, is it your primary reason? He said no. The question here is whether saving money was the primary reason. He indicated that saving money was not the primary reason. Right? The question is your position, your truthful position, that the primary reason for changing the nationality of Pac Rim Cayman was to save these few $1,000s in fees? No. Now, the reason that this is an admission that accessing jurisdiction was the primary reason is because throughout all of their pleadings and all of their statements, in fact, claimants have only alleged 2 reasons for changing nationality. One was to save money, and one was to access jurisdiction. If saving money was not the primary reason, then the logical inference is that.
Well, I query the logic. You can have 2 reasons without either one of them being primary. And if you're looking for a concession that it was the primary reason, we need to find clearer language. If you have it, show it to us.
I accept the President's logic, but it stands out that to me that it is that the preponderance of the evidence indicates that it was the primary reason for changing nationality was to access jurisdiction, because clearly saving money could not have been a significant consideration. Thank you. In any event, it is clear that access to jurisdiction was a reason, and therefore the second prong as regards whether the interference with the investment took place prior to Pac Rim Cayman's change of nationality is the only object of dispute here. Can you go? This is from the statement of Ms. Walter yesterday, indicating claimant's agreement that there is a single factual issue at issue, as I quote from day 1 at 265, 1-5. As I think we've understood by now, the question of whether there has been an abusive process in this case really turns on one critical fact, and that is whether the dispute arose before or after Pac Rim's change of nationality in 2007. Now, the next slide is the way that we formulated that question during our presentation. Did the alleged government interference with the investment take place prior to December 13th, 2007? These are slightly different formulations of the same factual questions. They agree that this is a factual question. We agree it's a factual question. And we also agree that this is the question that must be answered with regard to abusive process. Now I would like to address your question number 3 that relates to abusive process. If you could. The question is up on the screen, and it relates to the dictum in Maffesini, cited at Claimant's Legal Authority 80, which is Claimant's Legal Authority 81, paragraph 91 and onwards, and produced at Claimant's slide 10. And we've been asked to comment on this, which we will do now and again in writing when we have the opportunity. The elaborate steps articulated by the tribunal in Maffesini describe how a dispute may evolve in time but it is largely irrelevant for an objection on abuse of process. What is relevant is when the alleged state interference occurred or otherwise commenced. Mathesini addresses the question of the existence of a legal dispute for purposes of jurisdiction ratione temporis. It does not address the standard for abuse of process. They are not the same inquiry. There are two different legal concepts, and the factual inquiry of each one is distinct. That is why the tribunal in Mobile used the term born, that abusive process, the abusive process inquiry relates to when the dispute is born, which is a different stage in the development of a dispute, and I will explain myself, whereas the Massafini analysis, I think, leads to what has been called when a dispute is crystallized, and there are two different moments in the life of a dispute. And if you'll put forward the next slide, keep going. One more. I hope it got in there. The vagaries of overnight preparation, you'll forgive us. The tribunals in Mobile and Massafini identify different stages of a dispute as they are relevant to different types of objections. For abusive process objection, the tribunal in Mobile gives a determination legal relevance to the genesis of a dispute as when it was born. For the existence of a legal dispute for purposes of ratione temporis objection, the tribunal in Massafini describes and gives legal relevance to the final stage of a dispute between two parties. The stages essentially set out in Massafini, slightly modified for purposes of this, are set out here. It is El Salvador's contention that the abusive process factual inquiry looks to determine the moment at which the dispute actually began, not when it became a fully crystallized legal dispute ready for arbitration. It focuses on the moment in which the state took action which affected the investment, which is at the very beginning of a dispute. If you look here, the first thing that happens in a dispute is a state does something that affects the investment, and then the investor reacts to that, either accepting it or disagreeing. And then it would perhaps, in some cases, obviously the states in Massafini don't happen in real life every time. Sometimes there's no communication, but generally the investor would communicate its position to the state, and the state would either respond or not. And then the investor would communicate perhaps its legal rights to the state, and the state would respond or not. And then there would be a legal dispute because there's been an exchange of legal views, and the dispute has become a legal dispute. Our contention is that the abusive process inquiry starts at the very beginning of this. And why is this? Because the distinction between the real distinction here is between structuring an investment prior to going in so that everybody has notice of who the parties are and what their nationality is, which is clearly proper. There's another thing that might be done, which is restructuring after the investment has been made, but before there's any dispute or contention between the parties. And then there's a third moment where the nationality or the corporate structure is manipulated after the dispute arose or after the dispute is born. And why is it that the abusive process inquiry focuses on born? Because that is the moment when the investor knows, that's the moment when the investor knows that there is an issue that may someday be litigated. That is when the investor knows, that is when the investor can begin to manipulate its form after it has learned of the conduct of the government. And so that's the moment at which it becomes abusive. Although, now let's go back. Go forward a bit. Now let's, one more. Okay, you can leave it there for a moment. Although the measures claimant identified in the notice of arbitration as giving rise to its claims, those relating to the application for an environmental permit and the application concession, all occurred before the change of nationality. Mr. de Gramont said on Monday that the dispute first began to crystallize in the public statement of President Saka on March 2008. However, between December 2007 and March 2008, nothing new happened, and I will indicate why this is true. Even with the heightened standard articulated by the tribunal in Maffesini for the determination of a dispute, it is quite clear that by December 13th, 2007, okay, what I'm indicating here, if we look at the Maffesini formulation, which El Salvador does not accept for abuse of process purposes, but we're just indicating that if the tribunal were to apply this formulation, it would have been met by December 13th, 2007, with regard to the concession application. By December 13th, 2007, two applications have been filed. I'd like to focus here on the application for the concession, for the mining concession, which was, and contrary opinions had been exchanged on whether the requirements for attaining an exploitation concession had been met, including legal memoranda. By operation of law, due to Article 38 of the mining law, claimants' applications were terminated and denied by operation of law. Therefore, by December 13th, 2007, there was a clear and dramatic dynamic between the parties that would qualify for any definition of a dispute. There was the formulation of legal claims, there was discussion, and eventual rejection or lack of response by the other party. The facts clearly demonstrate that all of that happened before December 13th, 2007, with regard to the exploitation concession application, and it's clearly in the facts. So, can you go forward? At this point, I'm sorry, go back. It is also clear, one more forward, I'm sorry. Keep going, to Luis's. It is also abundantly clear from the record, from the testimony of Mr. Parada, which is uncontroverted, that claimants were preparing for arbitration prior to December 13th, 2007, and had every plan to submit an arbitration claim. If arbitration could have been submitted, then there was clearly a dispute for all purposes. Mr. Parada has submitted an unrebutted witness statement and testimony that claimant's counsel informed him of the existence of the dispute before claimant's change of nationality on December 13th, 2007, and well before claimant alleges there was even a possibility of a dispute in March 2008. Mr. Parada's recollection is supported by contemporaneous documentary evidence which reveals information whose source could only have been claimant's counsel. Is there any way to draw this out. This is an email from April 8th, 2008, from Luis Parada to the former Attorney General of El Salvador, and it indicates an ICSID arbitration against the Republic of El Salvador might be initiated under the CAFTA framework. Next. This is an email from Mr. Parada to Eric Swartz, also of Dewey and LaBeouf. We have been on top of that dispute since last December, when I first learned that opposing counsel was preparing for arbitration. Next. And finally, in Claimant's counsel's letter of April 22nd, 2011, in fact, Claimant's counsel indicated that on 24 October 2007, an attorney-client relationship between Crowell & Mooring and Pacific Mining Corp. And its subsidiaries had commenced. Claimant's counsel, who were party to the discussions with Mr. Parada in November and December 2007, were not only available to offer witness statements and testimony, but also have been participating in his hearings for 3 days. Their failure to offer any evidence, only insinuations, contrary to Mr. Parada's testimony, should lead to an adverse inference. This is the letter from Mr. Schrake to the President of El Salvador, Mr. Saca, of April 14th, 2008, and it indicates that on that date, Pacific Rim Mining of Canada had in mind initiating the controversy resolution process established in the Free Trade Treaty between Central America, the United States, and the Dominican Republic. Now, I'd like to go back to the point I was making. I'd like to go back to the point that I was making regarding the difference between the factual situation on December 13th, 2007 and March 11th, 2008, when claimants claim there was a legal dispute, a fully developed legal dispute on March 11th, 2008. And this is from the hearing transcript, day 1, 269, 18 to 22, again from Ms. Walter. But there was not a legal dispute, not until President Saca acknowledged or revealed, rather, the existence of what we call the de facto mining gen. Again, March 2008, after the change of nationality. So there was a legal dispute in March of 2008, okay? And claimant's position is that a legal dispute begins, for purposes of abusive process, when there's the formulation of legal claims, their discussion and eventual rejection or lack of response by the other party, okay? So for respondent, these criteria, for claimants, these criteria had been met by March 11th, 2008. That's their position, because not only have they alleged in their legal arguments that there was a dispute on this date, but shortly after this date, they threatened arbitration under CAFTA. So what is it in the record that could possibly have met their definition of a dispute by March 2008? The press reports of President Saca are nothing about the formulation of legal claims, their discussion, eventual rejection, or lack of response. There were no legal claims formulated there. There was no discussion, because President Saca was alone and not with anybody from the claimant when he made those statements. And there was no rejection or lack of response. When did that happen? All of those criteria must have happened before March 11th, 2008. When did they happen? They happened just as I described them in 2005 and 2006 and 2007 with regard to the exploitation concession application. I think, Mr. President, on this issue, my logic is sound. Can we go on? Now, let's look at the summary of events regarding the concession. Can you bring up the little... Now, the red area is the time between December 7th and April, should say April 14th, I think. But in any case, it's the time between when they changed nationality and when they threatened CAFTA arbitration, okay? And the only event in that time period are the press reports about President Saka, which we've discussed at length as to whether or not they actually do what Claimant says they do. All of the other actions of the government that could be considered the knowledge of the dispute, the discussion of the dispute, the presentation of legal opinions, and the rejection of that, all of that happened between December 2004 and December 2008. In fact, it all happened up to January 2007 with regard to the exploitation concession. And in fact, they've discussed a lot of communication with the government, or some communication with the government regarding the environmental permits and MARN after January 2007. There is nothing in the record. There was no communication, nothing after January 2007, because by that date, the dispute regarding the concession application, which is in fact their real source of rights, was over and crystallized at that date. Nothing happened between December 7th and March that could fit the definition of a dispute under Massafini. Now I want to just to bring home the point about what the Saka press reports meant or didn't meant. This is from the testimony of Mr. Shrake at 475, 12 to 18. Question, okay, do you have any other evidence from March 2008 that there was a ban on mining? Again, from March 2008. I'm asking about a specific, in March 2008 was the answer. Question, when at the moment this letter came out, intended to refer to press report, answer, no. No additional evidence of a ban in March 2008. So it's your position that on March 12, 2008, you knew there was a ban? No. Claimant's entire case up to now has rested on the statement that Mr. Saka's press, the press reports about Mr. Saka created a ban. Mr. Shrake, the CEO of Pacific Rim Mining, the manager of Pac Rim Cayman, the one person who has had primary responsibility for all of this, when asked if he knew there was a ban when the Saka article came out, said no. So the March 12, 2008, you did not know there was a ban? No. Okay, but on that date, but immediately thereafter, you threatened arbitration in a letter of April 14th, 2008. Is that correct? Then, okay, I did not know that every mining concession in El Salvador was eventually going to be expropriated. That sounds to me like I did not know there was a ban. I didn't know that at that point in time, but what I did know is that our efforts to get the government to follow the law with our particular asset had not been followed. And the indications were, with numerous consultations, was that they were going to continue to dangle and withdraw the carrot. Now, these numerous consultations must all have taken place before March 12, 2008, because he's referring to that time period. Therefore, it's the numerous consultations that made him realize that perhaps that his concession was in trouble, not anything that was said in the press article about President Saka.
Do you mind if we interrupt you, or is this...
no, I'm very happy for you to interrupt.
Because culturally some advocates, and I'm not one of them when I was an advocate, like tribunals that are completely silent.
No, I have no trouble if you would like to interrupt and if I can be helpful.
Take your point that you've just raised.
Okay.
I mean, that may be a very good merits point, is that really you've got nothing to complain about in March or April, because there wasn't a ban.
Right,
It wasn't a measure.
right.
And that may be a very good merits point. But is it a jurisdictional point?
It is a jurisdictional point for purposes of abuse of process, because their contention is that there was no dispute until this date. And that their contention is that there was a dispute on this date because on this date a ban was established. If no ban was established, there was nothing different on March 12, 2008 than December 13th, 2007. If there was no ban, nothing changed. Every fact that had occurred in the record occurred prior to December 13th, 2007. There's nothing in the record about the exploitation concession that happened between December 13th and March 12th. If no ban was announced, nothing changed. And if the dispute existed, as they admit it did, on that date, and they threatened arbitration shortly thereafter, which means they felt the dispute existed, then if it existed on that date, it also existed back in December because there was no change. The only change, they allege, is the ban. If the ban didn't exist, then all of the facts that made a dispute happen in March of 2008 were true and known and existent in December. If there was no ban, then the dispute must have started before this date. And if they threaten arbitration, they're threatening it based on facts that happened before December 2007.
Mr. Smith,
Yes.
I'm wondering, I didn't hear the respondent's view concerning the alleged conversations and promises with officers of El Salvador brought by Claimant. I would like to know the respondent's
I
views.
will go to that immediately. Just one point. After March 2008, when they alleged that something profound happened, they continued to invest millions of dollars in El Salvador, which seems to me inconsistent with their position that some momentous moment happened in March of 2008. There was a ban. Why would you keep investing money in a country where you thought there was an all-out mining ban? Continue. I, in fact, had anticipated this issue. The alleged assurances. Here are the alleged assurances. This is from Mr. Schrake's witness statement. From my meetings with El Salvadoran officials prior to 2002, merger with Dayton, well into 2008, officials at the highest levels in the Salvadoran government repeatedly expressed support for our project, and particularly, and listen to these dates, and particularly in 2007, and 2008, assured us that the permits necessary to conduct extraction activities at El Dorado would be forthcoming. I recall numerous such meetings on my many trips to El Salvador, and the next sections of his witness statements is the recitation of all of those meetings. And then with the letter of April 22nd of this year from Claimant's counsel to El Salvador's counsel, we heard of 2 more meetings. Now, this next slide, this is just from counsel's same position, assurances from 2004 to 2008. Next slide. These are the meetings. You will notice the gap. There were no meetings alleged from January 2007 to December 13th, 2007. Not one meeting alleged for the entire year of 2007, when they have based a large part of their argument that there was no dispute, that they were constantly getting assurances. But from the date of the termination by law of their concession application to the date of their change of nationality, they had no meetings. And I asked Mr. Shrake yesterday if he could recall any further meetings, and he said no. Now, there were other events in 2007. There were the statements of the Minister of the environment that were clearly indications of a disagreement and a dispute on a number of legal issues. But there were no meetings. If there were no meetings, it's hard to see how there could be assurances unless there were assurances in writing. And if there were assurances in writing, we would have had them in the record by now. Okay, we can go on. Now, that was my answer, a long answer to the question number 3 on abusive process. The next question I will address was your first question. Now we are correct in understanding that claimant's case then to be based upon a measure in or after March 2008 and not anything which took place prior to 2008, although they might be described as measures, they are not measures on the claimant's claim as based. Can you go to the next slide? It's El Salvador's position that claimant's constant reformulation of its claim in these proceedings cannot alter the abusive process analysis. Claimant cannot at this late stage, through statements of counsel, amend its notice of arbitration. And in fact, claimant hasn't offered any amendment to its notice of arbitration and continues to affirm the truth of the facts alleged therein, including the notice of intent. Its reformulation of the measure, even if permissible, cannot negate the facts that they have alleged and have told the tribunal must be assumed as true. Everything I went through in their notice of intent yesterday and put up here regarding measures and the consequences of those measures were allegations of fact which they have not denied, and I would assert at this stage they cannot deny. Nor does El Salvador accept those facts, but for purposes of this determination, the tribunal has been told to accept them by claimant. The question of whether or not the interference with dispute had taken place is a question of fact. It's not a question of what measures, what claims they make. It is a question of fact regarding the birth, the genesis of the dispute, if you accept our view, or the crystallization of the dispute, if you accept their view. But as they said yesterday, and we have agreed, this is a question of fact, not a question of how they formulate their claims. And let's look at their factual claims in the notice of intent. Their factual claim is that PRC's claims arrive out of El Salvador's arbitrary and discriminatory conduct, lack of transparency, and unfair and inequitable treatment in failing to act upon the enterprise's application for a mining exploitation concession. Okay, can we go to the next one? Now, I went through, I yesterday went through all of their allegations of fact to point out that the dates on which they indicated their investment was interfered with. I'm not going to go through all of that, but can you go to the very first paragraph in the notice of intent? Now, they have said yesterday that all of these measures that they alleged in their notice of intent to be breaches of CAFTA are somehow no longer breaches of CAFTA but are still measures. I'm not sure that it's appropriate to allow them to change that, but in any case, when they filed their notice of intent, they believed they were breaches of CAFTA. Now apparently they do not. But let's look at what they say as a matter of fact were the consequences of these measures, whether they're breaches of CAFTA or not. As a result of the measures, the rights held by the enterprises have been rendered virtually valueless, and PRC's investment in El Salvador have been effectively destroyed. Now, whether these measures are violations of CAFTA or not, whether they've changed their position on that, whether they've invented some new measure that's consistent with their temporal concept of the case, these measures that took place between 2004 and 2007, they have said and have not denied and cannot deny, because it is now their allegations of facts, these measures rendered virtually valueless and rendered the investment virtually valueless and have effectively destroyed the investment. All of this took place before December 13th, 2007. If a state has taken actions that render rights virtually valueless and destroy an investment, I would say a dispute has been born. I would say a dispute has been crystallized. I would say under any definition, a dispute exists, and they changed nationality after that dispute existed, after their investment had been not affected, destroyed. We can go through these I put up yesterday. I won't go through them again, but they clearly show the measures took place between 2005 and 2007. And then we also saw this yesterday. This is a press release from Pacific Rim Mining Corp of Canada in July of 2008, referring to their dispute with the government. And as we indicated yesterday, the dispute is described as, if I can read it, stalling the process without regard to the company's rights. This is 4 months after they allege the mining ban started. This is their public statement of what their dispute was when they were telling the world, this is our dispute. They said it was stalling the process. They didn't mention a mining ban. They didn't mention anything other than delay, which they repeatedly called measures in their notice of intent. Go ahead. I think the slides don't indicate our answer to your question number 4. With regard to, well, let me look. Okay, question number 2, which unfortunately I don't have a slide. With regard to abusive process, we will address in writing. I think there's some complicated issues of corporate law there that we didn't want to speak about extemporaneously. With regard to question number 4, it makes reference to the private placement financing, and whether it's actually a question to Claimant about whether there's more evidence in the record, but we went ahead and looked, and we're not aware of any further evidence in the record about the February 2008 private financing mentioned by claimants and referred to by Mr. Ali in Ms. McLeod-Seltzer's witness statement. But of course, Mr. Ali said much more in his presentation than Ms. McLeod-Seltzer's actually said, and his statement should not be accepted as facts in the record. There is no information as far as their reliance on this as some kind of proof that there was no dispute. There's insufficient information in the record for this to be used. There's no information in the record about the nature of the placement, about the details of what it was, of what was disclosed or not disclosed. Mr. Ali said they didn't disclose, but we don't know if they disclosed or they didn't disclose as a part of the offering. We don't know who it was offered to. A private placement could have been offered to current shareholders who are all managers and officers of the company, in which case there would be no reason to disclose. They extract too much from a few statements in a witness statement. And it should also be noted, although this is not in the record, they're free to deny it if they would like, Pacific Rim Mining Corp has continued to conduct private placements after this arbitration was initiated, belying the assertion that private placements can't be done if a dispute is known. Obviously, the world knows about this dispute. They know it's an arbitration, but they've continued to do private placements. So I would assert that the conclusion they would like you to draw from those few lines in Ms. McLeod-Seltzer's statement do not follow from that statement. Now I'd like to move forward to your questions on our objections ratione temporis. The question is, Section 38 of the mining law We would like the respondents to address the issue as to why respondents did not simply reject the application by claimant, and that's linked to the submission made by claimants. Basically, they were being used with a carrot and I guess a carrot dangled before them, as I think what they said. Article 38 of the mining law mandates the rejection of the application for the concession if the applicant did not cure any defect mentioned in the warning letter within a period of time specified in the warning letter. But this period cannot be extended. We've indicated that. In the current case, it will be recalled that the Ministry of the Economy was going out of its way to assist the applicant. Back in 2005, well, they have been trying to portray El Salvador as somehow being against them. Clearly, back in 2005, the Ministry of the Economy was trying to assist Pacific Rim Mining Corp. In getting its application right. They were getting the application wrong, and the government was bending over backwards and including doing things that in fact were not permitted strictly by law, that the bureaucrats did on their own, in order to give them continuing opportunities to correct. Okay? And what is it that they needed an opportunity to correct? It was two things. It was their ownership of land, which they've admitted they would rather have new legislation than correct, and it was their pre-feasibility study, which they say was a feasibility study, but the government said it wasn't. But by October 2006, the Bureau of Mines decided that it had waited long enough and decided to issue the warning letter invoking the provisions of Article 38 of the mining law. Regardless of whether the documents submitted by Prez in November 2006 complied with the requirements, it is undisputed that Prez did not submit the environmental permit because Marne had not issued it. And because of the argument on just cause, the Bureau of Mines, again bending the law in applicants' favor, granted an additional 30 days to submit the environmental permit because that was what was being requested and pressured by the company. The company, as you heard from Mr. Schrake, very, very vociferously lobbies all of the U.S. government, but also the Salvadoran government constantly to try to get the government to act in their favor. So it's very. So they issued a second warning letter. Now it's doubtful that the second warning letter changed the legal consequences, that the application for the concession was effectively terminated when the original 30-day period expired. But taking the most favorable interpretation to the claimant, even if the second period of 30 days was legally granted, that second period ended without claiming having provided the necessary documents. Therefore, the application of the concession was effectively terminated by operation of law in January 2007. As El Salvador admitted and as reflected in the tribunal's question, though, the Bureau of Mines did not take the formal step of issuing a resolution declaring the application terminated and sending the application to the file to archives. However, the non-performance of that formality does not change the legal effect that under Article 38 of the mining law, the application for the El Dorado concession was terminated by operation of law. Claimant complains that the fact that the formality of the termination was not completed was prejudicial, but it did not challenge it in court. This is incorrect, although this would have been an issue for the merits of the case if the case had gone to the merits and not relevant for jurisdiction. The information El Salvador has obtained so far from potential witnesses, again, who were not necessary for this jurisdictional phase, points that the non-performance of the
It's okay. Please finish. And
okay.
Then
The non-performance of the formality of declaring the application terminated was done with the intention, albeit ineffective, to help claimant. There's more if you want to ask. No.
Mr. Smith, just a question. What do you mean by bending the law? Is that possible?
Well, bending the law means doing what I mean is that they did something that was inconsistent with the law.
So what you're saying is that the Ministry of Environment was violating the law when it gave the extension?
The Ministry of Economy was acting inconsistently with the law, yes.
Okay.
But again, the extension was to was to benefit claimant. As the tribunal will recall, El Salvador stated in its written pleading during the preliminary objection phase that the second warning letter was withdrawn. The second warning letter was withdrawn precisely so that nothing would change officially, or that was the intent at least, because there was legislation that was going to be introduced to create a 3-year moratorium on mining. And pending applications, the way that, if I understand it correctly, pending applications, applications that were pending when the moratorium started would then be open to consideration when the moratorium ended. If that letter had not been drawn, or the intention was that it not, if it, let me try to say this clearly, if the 30-day period, if that letter had not been withdrawn, then they would have been subject, they would have not had the benefit of having a live application when the moratorium started. That was ineffective in any event, and their application was terminated by operation of law. In any event, the physical withdrawal of the letter did not have any legal effect because the second warning letter was not revoked. The second warning letter was notified to claimant, who does not dispute having received it and kept at least one copy. So the lack of revocation means that the letter still stood as well as its legal consequences. Claimant has also mischaracterized the expiration of the 30-day period as an act of presumed denial by administrative silence. And I just want to draw a distinction briefly between what happens under Article, what happens under Article 38 of the mining law and the general provision of Salvadoran administrative law. When an application is not responded to within 60 days under Salvadoran law, it is presumed denied, and the applicant has the right to seek redress in the courts. That's the presumed denial that claimants say we have given too much emphasis to. That is different from Section 38 of the mining law, which is a specific statutory provision that requires by its terms the rejection of an application and the closing of the file. And I just want to make sure that those two legal concepts are distinct. Now I'd like to turn to your next question on ratione temporis. You can, yeah, keep. And you ask another aspect. Another aspect of the mining law is simply this. As we stand today, going back in time to March 2008, has any foreign company been given an exploitation permit for underground mining for, first of all, as regards any foreign company, and separately as regards any local, this is national company? And if none has been granted, either none to a foreign company or none to a local company or both, what is the reason for that? The truth of the matter is that no foreign or national company received a mining exploitation concession in El Salvador since Commerce Group was issued its last concession in August of 2003. The truth of the matter is that since then, there have only been 2 exploitation concession applications. One was by Pacific Rim Mining Corp of Canada. One was by another company whose name I do not know. That other one was filed in 2005 and was rejected by the Ministry of the Economy in 2006. So since 2005, with the exception of Pacific Rim Mining Corp., there simply have been no mining exploitation concession applications.
Can you remind me, the Commerce Group permit was revoked. When was it revoked?
The environmental permit was revoked in 2006, and the revocation of the environmental permit resulted in them being unable to exploit under their exploitation concession. Now I'd like to address your questions under the investment law. I'd just like to make one general observation about our objections to jurisdiction under the investment law before we proceed. Before addressing the question, El Salvador has set forth 6 independent reasons why jurisdiction should be denied. If any one of these reasons is accepted by the tribunal, jurisdiction must be denied. Only the last of these objections relates to the fact that El Salvador has not given its consent to jurisdiction under Article 15 of the investment law, and we asked the tribunal to carefully consider each of these 6 grounds for denial of jurisdiction. Now, turning to your question, the first question on the investment law is again, as we understand the claimant's case, and we would like confirmation, the measure on which all their claims are based, including claims under the investment law, are described by Mr. Ali at day 1, page 137, from March 2008 and not before December 2007. We reserve our response to this in writing. It's not actually clearly directed at us, but we reserve the right to address it in writing. And the next question, which is more directed at us, the respondent has made several submissions about the indivisibility of these proceedings being based upon certain paragraphs in our decision, principally at page 86, and we understand the point they're making, but we want to make sure that it's not being advanced as an argument based upon res judicata, issue estoppel, or collateral estoppel, or anything else which prevents the tribunal from looking at the merits of the point. It is our understanding that's not been raised by the parties. We want to make absolutely clear that it is not an issue that we're being asked to consider, at least not by respondent. El Salvador confirms that it is not advancing an argument based on res judicata, issue estoppel, collateral estoppel, or any other doctrine related to those. However, we do maintain that judicial consistency would dictate that the tribunal should not make contradictory findings on the same issue in the same case. Therefore, if the tribunal dismisses the CAFTA proceeding, it must also dismiss the investment law proceeding, and I know that you indicated in your question that you understood our point, but I will make it just one more time. In the alternative, if the investment law proceedings were to survive alone, then it is our position, and I believe it is the correct interpretation of CAFTA, that it would clearly be the continuation of a proceeding with respect to a measure alleged to constitute a breach of Article 10.16 before another dispute settlement procedure, namely international arbitration. It would be the continuation of a proceeding, and it would no longer be the continuation of a CAFTA proceeding. Now, I come to, you have a question?
Maybe later.
Okay. Go ahead. Miscellaneous question. Now, we would like, if any point is being made about witnesses who should have been made available before this tribunal and have not been made, if we are being asked to draw adverse inference, we would like to know exactly what the submission would be and what the effect of that submission would be on this jurisdiction stage of the proceedings. Of course, El Salvador does not agree with Mr. Ali's insinuation that El Salvador failed to present any necessary witnesses. El Salvador has been able to fully prove its case without any additional witnesses. the factual question of when the dispute arose is abundantly proven by claimant's own notice of intent and other abundant evidence in the record. There was no need to put on fact witnesses to meet the burden of proof, which has been more than met. The tribunal will no doubt recall that by letter of April 27, 2011, El Salvador noted that the claimant had until very recently, and at El Salvador's insistence, had admitted that it had met with certain government officials, had not until recently admitted. El Salvador noted if claimant had disclosed the information about these meetings earlier, El Salvador would have been able to interview the officials mentioned. That Mr. Ali now takes this position on unavailable witnesses is surprising. With regard to inferences about the unavailability of witnesses, we would note the statement that I've already made with regard to Mr. Parada's witness statement and the inferences to be drawn from the lack of denial of those statements. That is the conclusion of my part of our final observations affirmatively. I will give the podium to Mr. Bedini to address our objections with regard to denial of benefits, and I think we will have ample time for our response later on this afternoon.
Well, thank you very much for making good progress. We would just like 5 minutes break now, which we'll take before the next speaker. So
thank you, Mr. President.
We'll just pause. Let's resume.
Good afternoon, Mr. President, members of the Tribunal. Again, my name is Aldo Bedini, and as Mr. Smith indicated, I will try to summarize these proceedings with respect to denial of benefits, at least as seen from the respondent's perspective. I tried in the small hours of the morning to heed the Tribunal's suggestion to focus on two things: the testimony that we've seen the last couple of days and the arguments that we've seen the last couple of days, rather than trying to merely rehash our previous arguments, and I will try to do that. The Tribunal also asked a series of questions relating to denial of benefits. I will try to at least give our preliminary thoughts on those. I have not structured my argument as elegantly as Mr. Smith has done around the questions, but I will try to work them in and alert you when I am addressing one of the questions. I would like to start, however, with a preliminary comment. I recalled last night Mr. Ali's beginning these proceedings with a cricket analogy, which I readily admit is a sport that I neither watch nor understand, and perhaps the two are related. If I watched it, perhaps I would understand it. But given claimant's relatively recent putative connections to the United States of America, I thought it would be more fitting to recall another sport and the immortal words of an individual whose name does not really roll off the tongue. He may be unknown to most, at least by name. His name is Ernest Lawrence Thayer, and I wanted to read as a preface the last few lines of a poem he wrote about that most American of all American sports. Oh, somewhere in this favored land the sun is shining bright, the band is playing somewhere, and somewhere hearts are light, and somewhere men are laughing, and little children shout. But there is no joy in Mudville, mighty Casey has struck out. We began these 2 days with respect to the denial of benefits on 3 issues. One, whether claimant has substantial business activities in the United States. 2, whether claimant is owned or controlled by persons of a non-party. And 3, whether our notice of denial of benefits was appropriate. The government of El Salvador submits to this tribunal that Mighty Casey has indeed struck out, at least with respect to the first 2 issues. And I say that because Mr. Shrake yesterday under oath effectively conceded points 1 and 2 in Respondent's favor. And I will briefly summarize the evidence where he has done that. As to point 3, we submit that that's basically a legal issue. I don't believe the facts are disputed as to the timing of the notice. And we will give you some outline today as to why we think the notice was appropriate, and we will further expound on that issue in our written submissions. So without further ado, let's turn to the first issue, whether claimant has substantial business activities in the United States. And let's go directly to what Mr. Shrake said yesterday. He admitted, first of all, that claimant performs no business activities in the United States or otherwise. It only holds shares. Question: how many employees did PACRIM Cayman have while it was registered in the Cayman Islands? Answer: it's a holding company. It doesn't have employees. Did it lease any office space? He asked incredulously, for no employees? No, it didn't lease office space. Did it own anything other than the shares? Verb being held, it's a holding company. Its purpose is to hold. It did nothing else. It held those shares. That's what a holding company does. And he continued. Question: did it have a bank account? No, it did not have a bank. So pretty much it existed on paper. Well, no, it's a holding company. The purpose of the company is to hold assets. And then Mr. Smith asked him, but what physical existence, what existence did it have other than on the documents that exist, perhaps in your office, and registered with the corporate registry in the Cayman Islands? Answer: none. He also admitted something that the claimants have tried to obfuscate from the beginning, but I think we finally got complete clarity yesterday, that claimant performs absolutely no exploration activities. He said PACRIM is a holding company. It apparently has no board of directors, but again, this is a company designed solely to hold assets. There is no exploration activities directly through that holding company. This is, as the name suggests, strictly a company to hold assets. And we looked at some of this evidence yesterday. There were third-party vendors who actually do the work, who look at the soil, who look at the mine, who plan the project. None of those companies, none of them, contracted or were directed by the claimant. And all of the finance, marketing, and administrative functions was performed in Canada. We've also seen numerous references in claimant's submissions to intellectual property and how valuable the intellectual property was that they sent to El Salvador. That was not the claimant's intellectual property. Mr. Shrake was asked, and in fact I think this question was from Mr. de Gramont, what was the role of Pacific Rim Exploration? That's not the claimant. What was the role of Pacific Rim Exploration? We're the mine finders. We are the wealth creators. We are the intellectual property of the company. And how did that contribute to El Salvador? It contributed everything to El Salvador. Now, with respect to investments, I won't go through this in detail. I just put up the slide as a reference. We have demonstrated that the investments in El Salvador were not from the claimant and they were not from the United States. Where is the evidence to the contrary? Next slide, please. The only evidence that is put up on this issue is a fragmentary document, which we've put up before. We don't need to show it again. It's that fragmentary page from a balance sheet. It's undated, there's no indication it was ever audited, and it's unconsolidated. Now, I heard Mr. de Gramont the other day say, quote, these were part of the company's audited, consolidated financial statements. With all due respect to counsel, first of all, it contradicts the face of the document, which says unconsolidated. Second, Mr. Krause, as well as the CEO, Mr. Schrake, had every opportunity to say that these were audited, that these were consolidated. They had every opportunity to say who created them, when they were created, and to put in the entire document. They did none of that. And even if the document is what it purports to be, as I spoke about the other day, a balance sheet, of course, as any accountant will tell you, it does not demonstrate the source of the investments. And the fact that they are carrying that on the claimant's books today doesn't prove anything about where those investments came from. But we know where they came from. And we know where they came from because Mr. Schrake told us where they came from. Yesterday, we looked at Annex H to Mr. Parada's witness statement, which was the July 3, 2008 press release of the Canadian parent. And I asked Mr. Schrake about that press release, which purported to quote him. And I asked, question, so when you said the company cannot continue to invest millions of dollars annually in advancing its El Salvador gold projects, the company you were talking about was the Canadian company, correct? Answer, yes. And again, if you look to the next, yes, this is the slide. I asked him further about that press release. And the language that's attributed to you is, quote, Pacific Rim and its predecessors have invested approximately $77 million on gold exploration and development in El Salvador with exceptional results, says Tom Schrake, President and CEO. Have I read that correctly? Yes. And again, Pacific Rim in that sentence is the parent company, the Canadian parent, correct. Yes, this is a news release for the parent company. So the evidence is undisputed that the investments came from Canada and they came from the parent company, and that claimant doesn't do anything but hold shares. Now, how does the claimant attempt to deal with all of this overwhelming evidence? There's only one way they can try to deal with it, and that's with a shell game. They say, don't look at the claimant and the fact that claimant does nothing and does not make the investments. You should look at all of these other companies. You should look at the Pacific Rim family of companies. And if there's any one piece of paper in this case that demonstrates just how much of a shell game this is, it was a piece of paper that was used by Mr. de Gramont on his opening the first day, and I'd like to put that up on the screen. This vertigo-inducing document with arrows pointing in all directions was Mr. de Gramont's attempt, claimant's attempt, to distract the tribunal from what is happening in this case. And if I may approach the board, their allegation is, and I've heard this in various forms, in the form of Mr. Schrake's testimony, in the form of the statements in their memorial, their allegation is, look, we do all this mining in Nevada with these companies, Dayton Mining, Nevada. Those companies make lots of money. And all of that money goes up here to the parent. And then the parent, through various avenues, and these arrows go all sorts of ways. I'm not going to draw the arrow because I'm not sure how they draw it. But through various avenues, they say it gets from the parent down here to El Salvador. And they also say there's intellectual property over here. There are geologists over here. I can't draw. When I say IP for intellectual property and geologists at Pac Rim Exploration. Let's assume that all of that is true. Let's assume they make all of this money in Nevada from the Dayton companies. All of the money goes up to the Canadian parent, and that money then that the Canadian parent makes from its Nevada mining operations is reinvested in El Salvador. They would have this tribunal hold that because of that, Pac Rim Cayman, whether Cayman Islands or Nevada, doesn't matter to this analysis, either pre or post 1207, they would have this tribunal believe that Pac Rim Cayman has substantial business activities in the jurisdiction of all of these other enterprises. The absurdity of that is demonstrated if we simply change the name here. They're creating confusion by the fact that these other companies are in the United States. But they just as easily could be, say, in India. Right? What if these mines were in India? And what if the exploration company were in India? If you accept Claimant's theory, the fact that this mine in India sent money to the Canadian parent, and the fact that the exploration company was also in India, all of those facts should be leading you to the conclusion that the Pac Rim company, which is a mere holding company, holding El Salvador companies, this now has substantial business activities in India. It's absurd, and the cases don't say that. The first authority that I would direct the tribunal to is, again, one that Mr. Chairman is familiar with, is the Plama versus Bulgaria ECT arbitration, where a very similar argument was made. A very similar argument was made. The argument was, don't just look at the claimant. Look at the other companies in the family to determine whether the claimant has substantial business activities. The tribunal noted that the claimant had no substantial business activities in Cyprus, and it said, and this is the key language, quote, contrary to the claimant's pleading, this shortfall cannot be made good with business activities undertaken by an associated but different legal entity, there it was Plama Holding Limited, even where PHL owns or controls the claimant. And what I've put up here, if you could go to the next slide, is a graphic illustration of the holdings in the Plama case. The claimant was a company that was owned or controlled by the parent, and the tribunal assumed, without finding, is my understanding, that the parent had substantial business activities in Cyprus. Plama held that's not good enough. The test is, does the claimant have substantial business activities? Now let's compare this to the facts of our case. Next slide, please. These are the facts of our case, and there are really two time periods at issue. One is the organizational structure before nationalization in the U.S. Here's Pacific Rim Exploration. This is the company that Mr. Schrake says has given everything to El Salvador. It's got the IP, it has everything. Pacific Rim Mining Canada has given the rest, which is the dollars, the Canadian dollars, I assume. And here's the claimant. What has it given? Where are its substantial business activities? Post-1207, now the claimant holds the exploration company. But the result should be the same as in Plama. The claimant here cannot take credit for the business activities of another corporate entity. Indeed, in Plama, it said even if the corporate entity was holding the claimant and that corporate entity had those business activities, that would not satisfy the test. So claimant, under the existing jurisprudential decisions, cannot take credit for the business activities of other companies, nor can it take such credit under a plain reading of the treaty language. Now let me turn to the issue of whether claimant is owned or controlled by persons of a non-party. I don't believe there's much dispute about the direct ownership by the Canadian corporation at all times. I've put up their admission to that in the counter memorial. As I said the other day, that should end the inquiry. Unfortunately, claimant has set forth a theory that is not supported by the language of the treaty. And this relates to one of the questions the tribunal asked, namely whether the practice of one or more agencies in defining national should have any bearing on this case. And it's the government of El Salvador's position that to define national other than expressly set forth in the treaty would be inappropriate. I have put up on the screen the CAFTA definition of persons of a party as a national or enterprise of a party. Chapter 10 of CAFTA defines national by reference to Annex 2.1. And the claimant, that's a quote from the claimant, not a quote from us, says that claimant states that for the Annex 2.1 states that for the United States, a natural person who has the nationality of a party means national of the United States as defined in the existing provisions of the Immigration and Nationality Act. What does the Immigration and Nationality Act says? It says a national of the United States is a citizen of the United States or a person who, though not a citizen, owes permanent allegiance to the United States. Claimant makes an admission that the manner in which U.S. law, particularly the Immigration and Nationality Act, defines nationality is determinative. So it would be inappropriate to use rules of thumb. But if I may step back, why are we even talking about this issue? The reason we're even talking about this issue is because claimant says the ownership or control of the claimant by the Canadian parent should be disregarded. We don't believe that's appropriate. We don't believe the tribunal should even get to this issue. But we submit that if the tribunal does go to the issue of the ownership or control of the parent, you must apply the treaty definition of national and not consider U.S. stockholders who are merely resident in the United States. Excuse me. Now, let me briefly talk about control, and let me show you what Mr. Schrake said about control. Mr. Schrake admitted that he makes all of the decisions relating to mergers and acquisitions, investments, and corporate ownership. Now, again, these were a series of questions I wish I had asked because the answers are very revealing, but in fact, Mr. de Gramont asked these questions. Question: now you testified that Pac-Rim Cayman made a number of acquisitions and dispositions over the years. Do you recall that? Yes. So, for example, in 2001, Pac-Rim Cayman decided to sell its Argentine assets. Do you recall that? Yes. And whose decision was that? Mine. And then it took the proceeds from the Argentine sales and reinvested them in El Salvador. Who decided that? I did. And then in 2004, Pac-Rim Cayman became the 100% owner of Pacific Rim El Salvador. Who decided that? I did. And then in 2005, Pac-Rim Cayman became the 100% owner of the other Salvadoran subsidiary, Dorex. Do you recall that? Yes. Who made that decision? I did. And then the most fundamental corporate decision, as I said the other day, a corporation can make to change its state of incorporation. This question was asked. Question: and then in 2007, Pac-Rim was domesticated from the Cayman Islands to Nevada. Who made that decision? I did. Now, I asked myself last night, why would Mr. de Gramont ask these questions to elicit these answers? And I came up with two hypotheses. One hypothesis is that Claimant seeks to argue that because Mr. Shrake, in addition to being president of the Canadian company, which he is, he's also president, treasurer, and secretary of Pacific Rim Exploration, the exploration company which he said has given everything to El Salvador. And perhaps the argument is that because he's president of that company as well, the exploration company, and that's a United States company, the activities of that company is something that the claimant can take credit for. And they can argue that that company was controlling the claimant. The problem with that argument, first of all, there are a couple of problems with it, is it's completely inconsistent with the Plama decision and the decision of other tribunals with respect to not being able to take credit for the activities of other entities. But there's a second possibility I thought of. Aside from the taking credit for the business activities, perhaps he's saying that in his role as president of this U.S. company, that U.S. company is controlling the claimant, and therefore there must be control by a party. Well, the problem is the claimant has it precisely backwards. Let me show you the organizational charts again. This is the organizational chart in 1997. Here's the claimant. Here's the exploration company. I'm sorry, it's a little grayed out, but this is from their exhibit, I think it's C21. If the claim is that Pacific Rim Exploration controls Pac Rim Cayman, this chart demonstrates the fallacy of that argument. They're both controlled by the Canadian company. Well, maybe things changed after 1997. Let's look after 1997. Let's look to C55, immediately prior to the December 2007 restructuring. Here's the claimant, Pac Rim Cayman. Here's Pacific Rim Exploration. Again, is Pacific Rim Exploration and Mr. Shrake wearing his hat as president of Pacific Rim Exploration? Is he controlling the claimant? No, they're at the same level. They're being controlled by the parent company. And finally, let's look at the ultimate structure that resulted from all of these corporate manipulations. We've got up there R126, which we marked yesterday. And what's interesting here is that here is the claimant, and below it is the exploration company. So the claim cannot possibly be that the subsidiary here is controlling the claimant. So that leads me to the question that I asked myself. Mr. Shrake obviously was telling the truth when he was saying that he made all these decisions himself. Was he making those decisions wearing his hat of president of Pac Rim Exploration, or was he making those decisions as president of the parent Canadian company? We don't have to speculate. He told us what hat he was wearing. Let's look at his testimony. As I said, he's the president and chief executive officer, not just of the exploration company, but of the Canadian parent. It was in that role, wearing that hat, that he directed all of those subsidiary companies. I asked him this question: are you able to point to any documentation you're aware of that suggests that Pac Rim Cayman ever had a board of directors? Answer: Pac Rim Cayman, again, is a holding company. The board of directors of Pacific Rim Mining Corp. is, and myself, as the chief executive, direct Pac Rim Cayman as a holding company. He expressly admitted all of those things that Mr. de Gramont asked him about, all of those corporate decisions, he was doing those as the chief executive of the Canadian parent. And just to clarify it, I said, you say the board of directors of Pacific Rim Mining Corp. direct Pac Rim Cayman. You're talking about the board of directors of the Canadian companies, correct? Yes. And as if there were any remaining doubt, you'll remember that Mr. Schrake wanted to go up to the chart to make his own circle around the family of companies, and I, of course, invited that. When a witness asks me if they can draw on my chart, I always say yes. And he said, in response to that drawing, Pacific Rim Mining Corp. owns all of the companies, all of the holding companies, all of the operating companies, all of the local subsidiary companies, and Pacific Rim Mining Corp. is owned a majority by U.S. shareholders. And then after he made that circle, I asked him, and does Pacific Rim Mining Corp. also control all of these companies you just circled? Answer, yes. And you can see for yourselves, the companies he circled includes the claimant. That should be the end of the control issue. Finally, let me turn to the issue of notice and whether El Salvador provided timely and appropriate notice relating to denial of benefits. I've put up on the screen Meg Kinnear's treatise, which an excerpt from the treatise, rather, which I will not read, but the point of it is that it really makes no sense to require that notice before a claim is submitted to arbitration for all sorts of prudential reasons. We've seen how quickly these shell games can happen. We've seen how corporation ownership or control can be changed. It is unworkable to expect a party to keep up with that and to know when they have to provide notice of denial of benefits prior to the time that jurisdictional objections in an arbitration are due. Now, El Salvador had no reason to invoke denial of benefits, certainly before it knew of claimant's U.S. nationalization. In fact, claimant concedes this in its papers. And that notice was not until June 2008. Even at that time, that notice was not a formal notice that was sent in a letter to high-ranking El Salvadoran officials. It wasn't even volunteered by the claimant. It was in response to a question from the entity responsible for registering investments in El Salvador. And after a number of months, they responded and said, yes, there's been a change of nationality. But even if the knowledge that this agency knew about the change of nationality, even if that's imputed to all of the El Salvadoran government, that would not put us on notice that this is the entity that is going to commence an arbitration, or that this is the entity that's going to claim, contrary to fact, as you've seen, that they made all of these investments in El Salvador and therefore are a covered investor subject to the protections of CAFTA. We would have no way of knowing that. And this is a response, I believe, to one of the questions, which was El Salvador in a position to invoke the denial of benefits when the notice of intent was filed? The answer we submit is no. The notice of intent raised more questions than it answers. A claimant, for one, alleged that it was an American investor and that it had made the investment in El Salvador. That would require an investigation into whether claimant in order to invoke the denial of benefits at that time, that would require an investigation into whether claimant had substantial business activities and whether they were owned or controlled by a person of a non-party. That investigation was completed in part by the time we gave notice to the U.S. Trade Representative on or about March 1, 2010, but the investigation continued. As this tribunal knows, we were obliged to invoke the tribunal's assistance to obtain additional discovery, to have further demonstration of our basis for denial of benefits.
At some stage, and I think this is more for your post-hearing submissions rather than now, it will be very helpful to go through your letter to the United States of America and indicate what further information you needed that is not in that letter, which makes up for your present case as regard denial of benefits. Because that's quite a long, detailed letter. And that, I think, was prepared without the benefit of this tribunal.
That's correct. And that actually, we will do that, Mr. President. And that actually leads me into an answer to one of your other questions. If you could put up the next slide. One of your questions was why the delay between that letter and when the denial of benefits was invoked in this arbitration. And with respect, we would submit that the question is really put the other way. Why did we provide notice 5 or so months earlier than we think we were required to? It is our position, as we put up on the screen, that the denial of benefits invocation really has to take place by the time jurisdictional objections are made in an arbitration, which is normally at the time of the counter memorial on the merits. If it is not made by that time, we think it is waived. And as you asked in yet another question, can you wait until after an award has been made? No, we don't think you can wait until after an award has been made. So why did if that is our position, and I think it's a very reasonable position given what is involved in the process, why did we provide notice to the United States Trade Representative 5 months earlier? And the answer is because this really is the first denial of benefits that we're aware of under CAFTA or NAFTA, and because we take seriously the opportunity of the United States government or any other affected party to engage in state-to-state consultations, we wanted to give them the opportunity to say to us, El Salvador, you are wrong. El Salvador, you've misunderstood something here. El Salvador, you don't have your facts straight. And despite that opportunity, we have not heard anything. El Salvador has not. Of course, they may. But that is why we gave notice at a time earlier than the time we thought was required. Now, the reason we think it is appropriate to wait, or I should not say wait, the reason it is inappropriate to require notice and invocation before the arbitration is that a lot of things have to happen. You have to make this factual investigation. You have to hire counsel. Many of the parties involved in these types of disputes do not hire counsel until after the notice of intent has already been filed. And we were hired shortly before the notice of arbitration in March of 2009. Now, and if you could go to the next slide, this interpretation that we're urging is not an unusual interpretation. The Emelich decision involved the U.S.-Ecuador bit, and like CAFTA here, The issue there did not, the bit there at issue did not require that investors receive advance notice, and the tribunal held that the objections to jurisdiction phase was the proper phase of the proceedings. Now, it's significant, members of the tribunal, that in all of the reams of paper that we've seen relating to the timeliness of denial of benefits, there has been no coherent argument advanced as to how claimant has been prejudiced. If benefits had been denied earlier, they would not have been injured in some way. The only thing close to an argument of prejudice is this argument that's not supported by the text of the treaty, which goes something as follows, if I understand it correctly. Well, by waiting so long, you've interfered with the state-to-state consultation process, because the United States may be afraid to engage in that process, because if it does, El Salvador will accuse it of having improperly provided diplomatic protection under the ICSID Convention. Well, first, there is no authority that we are aware of that says that engaging in those state-to-state consultations would constitute diplomatic protection. But lest there be any doubt, we have consulted with the government of El Salvador, and I am authorized here today to say the following. El Salvador does not interpret the initiation of consultations under the denial of benefits provision in CAFTA as in any way constituting diplomatic protection for purposes of Article 27 of the ICSID Convention. Therefore, if the United States of America wishes to initiate such consultations with El Salvador with respect to the invocation of the denial of benefits, El Salvador would not have any objection to those consultations on the basis that they would amount to diplomatic protection for purposes of Article 27 of the ICSID Convention. And El Salvador expressly waives any right it might have to object to those consultations on that ground. Now, finally, the tribunal has asked whether it would be useful if the United States were to comment on this issue. We believe it would be useful. The tribunal can, of course, decide and will decide in its discretion how to formulate that request. But we do, again, remind the tribunal that this is the first time that the denial of benefits provision is invoked under NAFTA or CAFTA. And finally, I would just put up on the slide, put up on the screen rather, the Meg Kinnear treatise again, and a quote she has in there about the fact that parties have an opportunity to come in and complain if they believe that the denial of benefits is inappropriate. And with that, I will close and thank the tribunal for its time.
Thank you very much.
I believe we may have 10 minutes or so to reserve. Thank you.
20 minutes. 20 minutes. The Secretary tells us that you have 20 minutes left.
I was being conservative.
We were now going to have our mid-afternoon break. We had a slightly longer break than we should have had earlier in the afternoon. How long do you need now? If you want 30 minutes, of course you can have it.
That would be helpful because we don't have our colleagues here yet. They are upstairs. Excuse me, if we could perhaps start at 3.
Let's adjourn till 3 o'clock.
Thank you. And Mr. Chairman, will the Tribunal address the... Thank you.